Now I'd like to tell you about some of the very difficult changes that have occurred in the law, particularly concerning allegations of abuse. First of all, changes in the hearsay rules are particularly dangerous. For many years, hearsay has been outlawed as unreliable. How do you attack somebody that isn't in court? How do you attack a document or something that somebody was supposed to have said when they're not there? Hearsay has always been thought to be dangerous for these reasons. When a child is alleged to have said something to a therapist, and for some reason the child is unavailable, or the prosecutor insists that it's too traumatic for the child to come and testify, the prosecutor will attempt to get the therapist to come in and say what they think the child has said. Of course, this is hearsay, but many states create exceptions for statements allegedly from children when they are given in court by a therapist. When that doesn't work, many states use what's called a catch-all hearsay exception. That is to say, if it's not a statement that's made for the purpose of medical diagnosis, or if it's not a statement that is a present sense impression, which could be seen to have some reliability, the prosecutors insist that the statement should come in under the catch-all exception to the hearsay rule. This is quite dangerous for defendants because it is very difficult to defend against. Of course, many say that the new case of Crawford versus Washington has some impact in this area, but it's difficult to push prosecutors and many judges off their biases. Then there are the propensity rulings. After about 200 years of prohibiting propensity testimony, many states are allowing in propensity evidence. An example would be, because Bill had an allegation of inappropriate sexual contact with someone 4 or 5 years ago, that means that Bill is probably the kind of guy that had inappropriate sexual contact with this particular complaining witness. That's very dangerous, and it's propensity evidence. It has a propensity to show that Bill does these kinds of things. Problems with extrinsic evidence of character are now coming about. Many states have outlawed extrinsic evidence of character, but with respect to the issue of child abuse and sexual abuse cases in general, and in physical abuse cases coming online now, we see extrinsic evidence of character creeping into trials. It is also very difficult to fight against. What happens when the defendant wants to testify that he's not the kind of guy who would do what he's accused of doing? Many states see this as opening the door to allowing in all kinds of propensity evidence, such as, in 1973 this happened, in 1985 that happened, etc. Another set of difficult laws that we have to face in these cases are the sentencing laws. Sentences to prison are mandatory in many states if force or duress is used. What is force or duress? What does it mean? When the legislation was originally passed, it meant strong physical and bodily force. Now, the law and order and the get tough on crime folks say that force can be something as little as pushing a piece of paper across the table. That requires force, so that's force according to these prosecutors. Let me say again that when the legislatures of the various states passed the laws concerning the use of force, they were anticipating that force meant holding the victim down, grabbing them, abusing them in some terrible way, forcing them into the room, etc. But in many recent cases, just putting your hand on the alleged victim's shoulder and moving them down a hallway is considered force. Let me say again that when the legislators of the various states passed the laws concerning the use of force, they were anticipating that force meant holding the victim down, grabbing them, abusing them in some terrible physical way, forcing them into the room. But in many recent cases, just putting your hand on the alleged victim's shoulder and moving them down a hallway is considered force. Another example from a recent case was that the defendant is alleged to have put his hand on the alleged victim's head and guided her towards some sort of sexual interaction. That was considered force as well. No real harm, no bruise, no bleeding, or anything of that nature is necessary now. Any kind of force is seen to constitute force for the purpose of increasing sentences and requiring mandatory prison. There are other laws that are difficult to deal with in the child abuse and abuse scenarios. Another one is the strikes law. Previous felony convictions are considered strikes. If there is force or duress, that is also considered a strike now. Another difficult issue with respect to the new laws are the percentages for good time and for working in prison. If someone does happen to be convicted, often they can get out for good behavior with 50% of their time served. This is not the case for sexual criminal convictions, where many states are passing laws that instead of allowing the convicted defendant out after 50% of their sentence, 4 years on an 8-year sentence, they must now serve 85% of their time before they can even be considered for probation or parole. Another difficult change in the law with respect to sex offenses are the registration laws. While it is a good idea to keep track of people who are predators, this is a law that enforces with too broad a sweep. Most states require people who have been convicted of sexual crimes to register once they come out of prison and register every year for the rest of their lives. Some states are so restrictive that if a person leaves their primary address for more than 5 days, they have to re-register in the place that they're going. Imagine going on vacation with your family to Yosemite or Tahoe or Hawaii or Florida for a week. If you're going to be away for more than 5 days, you've got to go to the police department in the city where you and your family are vacationing and register as a sex offender. Within 10 days of your birthday, you have to register every year. You have to register with the police department in every new city that you go to. Another difficult change in the law for people involved in allegations of sex crimes is Megan's Law. It used to be the case that only the police had access to convicted sex offender information. Now, it's at every police station available for public view. In some circumstances, it's available on the internet. The problem is that if you ever get put on this kind of a registry, where you live, they'll tell your neighbors, everyone will find out. You see, it's not over when it's over. Another difficult change in the laws concerning sexual offenses is that after serving a sentence for one of these crimes, many states are requiring that psychological evaluations occur. These evaluations are done with people who have a very restrictive sense of how human beings are and how human beings behave. This always works against a convicted defendant. That is to say, many states require what they call sexual predator evaluations. This occurs after the sentence is completed and before the state will let a convicted defendant free. You see, many states require that if you don't pass the sexual predator evaluation, you can be kept beyond the term of your sentence for mental health confinement as a danger to the public. The defendant is then kept as a danger to the public until he can pass the sexual predator evaluation. With the new laws in place, most convicted defendants never pass the sexual predator evaluation.